In theory, parties to a contract are free to choose their own contractual terms and are then bound by these terms. It became clear by the 19th century, however, that many individuals were bound to terms with which they had no choice but to agree, or which they had no real notice of. This was exacerbated by the rise of standard form contracts. At common law, judges had little means by which to free individuals from such terms. Great lengths were often undertaken to find a particularly onerous clause that was not incorporated into the contract, or that the clause, properly construed, did not cover the actual event which had occurred. This was particularly true when a party sought to exclude liability for their own negligence or for a fundamental breach of contract. The need to protect consumers was addressed by the enactment of the Unfair Contract Terms Act of 1977 and the Unfair Terms in Consumer Contracts Regulations of 1999. Adherence to freedom of contract makes courts reluctant to invalidate the substance of clauses which attempt to limit or exclude liability. Instead, they have developed rules relating to the incorporation and construction of clauses as a means of controlling their effect. Incorporation means, is the clause a part of the contract? Construction means, does the clause cover the breach? More specifically about incorporation. In order for an exclusion clause to be effective, it must be incorporated as one of the terms of the contract. Incorporation is in fact a requirement for any term of the contract, and the rules outlined here do not just apply to exclusion clauses. There are three main ways in which incorporation may take place. First, the clause may be included in a contractual document which has been signed by the other party. An example is the case of Lestrange versus Graukop from 1934. The party signing will be bound by the clause even if it has not been read or understood, provided that the other party has not made any misrepresentation to its effect. Secondly, the clause, even if not in a document which has been signed, may be incorporated provided reasonable notice of it has been given at or before the time of contracting. Notice will not be reasonable if it comes after the contract has been made. See Oley versus Marlborough Court Hotel from 1949. The test of what is reasonable, assuming that the clause has been put forward in time, was first stated in Parker versus Southeastern Railway in 1877, and it is clearly a question of fact to be determined in light of all the circumstances. A number of cases have made it clear that the more unusual or onerous the clause, the more must be done to draw it to the attention of the other party. This is commonly referred to as the red hand rule. See, for instance, the case of Interphoto Picture Library versus Stiletto Visual Programs from 1988. The third way in which a clause may be incorporated, in addition to signing and reasonable notice, is through a course of dealing. If the parties have regularly dealt with each other and the exclusion clause has always in the past been part of the contract, this may in itself lead to a presumption that the clause will be incorporated in any new contract, even if on this occasion reasonable notice of it has not been given. See, for example, Kendall and Sons versus Lilico from 1969. The issue of construction. Once it is established that the clause is part of the contract, the next issue is to decide whether on its true construction the clause covers the particular breach which has occurred. The courts have traditionally been strict in this area and interpret any ambiguity against the person trying to rely on the clause. This is sometimes called the contra proferentem rule. There remain problems, however, with deciding whether a clause covers liability for negligence in the performance of a contract, particularly where the negligence is by an employee of the contractor. See, for instance, Canada Steamship Lines versus the King from 1952 and White versus John Warwick from 1953. The issue of fundamental breach. At one time, the courts, and in particular the Court of Appeal, developed a rule by which it was held that an exclusion clause could never be effective against a particularly serious breach of contract, what is called the fundamental breach. What is then this fundamental breach? There are two main categories. The first is where the breach relates to a particular obligation which is central to the contract. The second category of fundamental breach arises when the consequences of the breach are exceptionally serious. The approach to fundamental breaches was, however, reviewed by the House of Lords in Swiss Atlantique in 1967 and in Photo Production versus Securicor in 1980. Although it may be difficult to convince a court that an exclusion clause was intended to cover a breach which has deprived the other side of all benefit, provided that it's clearly worded, courts will not refuse to apply it for this reason. The Unfair Contract Terms Act 1977 provides a statutory framework for the regulation of exclusion clauses. It operates alongside the common law. It is still possible, therefore, for a clause to be struck down by the common law rules without needing to consider the effect of the Unfair Contract Terms Act. It is necessary when looking at the validity of a clause to consider both the common law and the statutory controls in the form of both the Unfair Contract Terms Act and the Unfair Terms in Consumer Contracts Regulations of 1999. The Unfair Contract Terms Act 1977 is primarily concerned with exclusion and limitation clauses rather than unfair terms in general. Virtually all of its provisions are concerned with business liability, see for instance Section 1(3) of the Act. The Act deals with clauses which attempt to exclude liability for negligence in Section 2. Negligence is defined as covering an obligation to take reasonable care in the performance of a contract, the tort of negligence, and liability under the Occupiers' Liability Act of 1957. The Unfair Contract Terms Act separates out negligence resulting in death or personal injury from negligence leading to loss or damage to property. As regards death or personal injury, Section 2(1) provides that there can be no exclusion or limitation of such liability arising from negligence. Any clause in a contract which purports to have this effect will therefore be void. The exclusion of contractual liability other than through negligence is covered by Section 3 of the Unfair Contract Terms Act. This applies in two situations, where one of the parties deals as a consumer, and where one of the parties deals on the other's written standard terms of business. Note that in relation to the second of these categories, it can apply as between two business contractors. All contracts on written standard terms are therefore potentially within the scope of Section 3. The phrase, "in the course of a business," is thus crucial to the definition of who is a consumer for these purposes. It is not further defined in the Act, but the case of R&B Customs Brokers versus UDT from 1988 shows that it does not necessarily apply to all the activities of a business. The Unfair Contract Terms Act contains special provisions in Sections 6 and 7 dealing with contracts for the sale or supply of goods. In relation to the statutorily implied terms as to title that operate in relation to such contracts, the Act prohibits any exclusion of liability. In relation to the implied terms as to the description or quality, for example under Sections 13 and 14 of the Sale of Goods Act 1979, the position depends on whether the buyer is dealing as a consumer or not. The test for whether this is so is the same as that discussed above in relation to Section 3 of the Act, with the addition of a requirement that the goods concerned must be of a type ordinarily supplied for private use or consumption. See Section 12(1)(c) of the Unfair Contract Terms Act. If a buyer is dealing as a consumer, there can be no exclusion or limitation of the implied terms as to the description or quality. If the buyer is dealing otherwise than as a consumer, then liability under these terms can only be excluded or limited insofar as the clause satisfies the requirement of reasonableness. In a number of situations, the Act makes the validity of an exclusion clause dependent on whether it satisfies this requirement of reasonableness. The test for the requirement is dealt with by Section 11 and Schedule 2 of the Act. It has also been considered in several cases, such as Stuart Gill versus Horatio Mayer in 1992, Overseas Medical Supplies versus Orient Transport from 1999. Schedule 2 to the Act contains a list of factors we should be taking into account in assessing reasonableness. The Unfair Terms in Consumer Contracts Regulations of 1999 result from the implementation of the European Directive, reference 93/13/EC. There is considerable overlap between the effect of the Unfair Contract Terms Act and the regulations in relation to exclusion clauses. For this reason, the Law Commission has recommended that the two pieces of legislation be unified into a single legislative scheme. See, for instance, Commission Report 292-646 from 2005. As they stand, however, there are some important differences between the two pieces of legislation. The regulations apply only to consumer contracts. A consumer is defined by the regulations as a natural person acting for non-business purposes. The approach taken in the R&B Customs Brokers versus UDT case from 1988 in relation to the Unfair Contract Terms Act does not apply to the regulations. The regulations apply to all types of contracts other than those that have been individually negotiated. They are not limited to dealing with clauses which have the effect of excluding or limiting liability. The test of fairness is set out in Regulation 5.1. It states that a term will be unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer. There are two main elements to this test: good faith and significant imbalance. The relationship between them was considered by the House of Lords in the case of Director General of Fair Trading versus First National Bank from 2002. A significant imbalance arises if a term is so weighted in favor of the supplier as to tilt the party's rights and obligations under the contract significantly in his favor. Good faith, on the other hand, relates to the need for fair and open dealing. In other words, it requires that the consumer is given full information and that there are no pitfalls or traps in the contract. Schedule 2 to the regulation contains an illustrative and non-exhaustive list of terms which may be regarded as unfair. The test of fairness does not apply to clauses which define the main subject matter of the contract or the adequacy of the price, Regulation 6.2. The fairness test, in short, does not operate to prevent the consumer from making a bad bargain, for example by paying too much for goods of poor quality. Clauses relating to these matters are subject only to the requirement of intelligibility explained in Regulation 7.